because they have hired prominent advocates.
The Anti-Corruption Court is trying the offence of corruption against legislators Yusuf Mutembule for Bunyole East, for Akamba for Bosiki constituency, and Sise Namuju, woman member of parliament for Ruengo district. During the last court sitting, legislators applied for bail, although prosecution objected.
Of the TIA Cap 25, he dismissed the medical condition of documents of A1 and A3 as falling short of the requirement to have them obtained from a prison medical officer. Regarding sureties, he submitted that though they are members of parliament, they had not produced their bank statements to demonstrate capacity to meet the terms of the bond. He argued that being an MP does not mean the capacity to pay the bond. He asked court to consider guideline number 13 in the Legal Notice 8 of 2022, which lists considerations to be taken into account before granting bail. He concluded that the greater interests of justice favor the continuation of the trial rather than the grant of bail. In rejoinder, Mr. Laka, his loud noise, contested the submissions of the state by stating that the right to apply for bail and the discretion of the court to consider the same are not fettered by any guidelines in place. He submitted that Section 16 of the TIA is directory and not mandatory. He argued that the presumption of innocence is a constitutional matter, that MPs have fixed places overboard, and dismissed the insinuation that they have no places of residence. He stated that the accused had been on remand for 52 days and that the fact that the trial as started does not deprive them of the right to apply for bail. Guilty. Messrs. Ocheng and Bihayo concurred. Consideration by court. I have perused the applications and their attachments. I've addressed my mind to the objections raised by the respondents. Bail is a temporary release of a prisoner from detention to enable him or her attend trial from outside prison. It is a discretionary power of court which it exercises to balance the promotion of the accused's rights to the presumption of innocence and the need to protect society by keeping persons that transgress the law from circulation until the trial is concluded. So it's a balancing act. Before granting or refusing bail, courts consider the gravity of the offense and the likelihood of the prisoner to flee rather than turn up for the trial. Courts also consider whether the accused has a fixed place overboard where he or she lives. The accused's antecedents, such as the commission of similar offenses or the likelihood to commit another crime, also have a bearing on the matter of bail. The presence or absence of substantial sureties who have influence upon the accused to attend court and have capacity to meet the terms of their bond is another important consideration. The likelihood of the accused to interfere with witnesses or exhibits or investigations generally are matters that weigh in on the decision to grant or to refuse bail. Bail should not be denied just because the state wishes to keep a prisoner in jail when it has not proved the case against him or her. The fate of a prisoner should be determined expeditiously through trial rather than by indefinite detention. And bail is one of the matters to be considered, even when the trial is on, provided factors for the release on bail exist. There are three issues for resolution in this matter. The first, whether the applicants need to furnish exceptional circumstances. Two, whether or not sureties are substantial. Three, whether the applicants merit to be released on bail or not.
Judge Lawrence Gidudu, presiding over the case, after perusing all sides' submissions, granted the legislators bail under stringent terms.
Circumstances. Section 16 of the Trial on Indictments Act reads, I quote, "Notwithstanding Section 15, the court may refuse to grant bail to a person accused of an offense specified in subsection 2 if he or she does not prove to the satisfaction of the court, A, that exceptional circumstances exist justifying his or her release on bail, and B, that he or she will not abscond when released on bail." And in subsection 3, exceptional circumstances are defined as grave illness certified by a medical officer, from the prison, and B is a certificate of no objection signed by the DPP, and C is the infancy or advanced age of the prisoner. This provision mandates courts to require an applicant to furnish exceptional circumstances if it is inclined to refuse the grant of bail. There should be evidence adduced to move the court to refuse bail unless exceptional circumstances are proved. Oftentimes, courts are asked to apply that provision when no compelling evidence has been availed for such a decision to be made. To put the matter into context, a court would consider to invoke the provisions of Section 16 of the TIA if, for example, it was shown that the crime committed by the applicant involved the use of violence, causing death or destruction of property, or endangered lives of children or vulnerable persons. Such acts that create fear in a society would compel the court to frown upon a bail application unless exceptional circumstances are furnished as defined in Section 16, subsection 3, paragraphs A, B, C of the Trial on the Indictments Act. The purpose would be to protect society from such offenders and lawlessness. In economic crimes such as the current case, if colossal sums of money are stolen or lost or received, and the state is making efforts to trace, identify, and seize the same or the proceeds in form of laundered assets or property, it would compel a court to keep the accused on remand to reduce the risk of disposing of the proceeds of crime. This would ensure that the offender does not destroy evidence or frustrate asset recovery. In short, court does not automatically invoke the requirement for exceptional circumstances just because the crime is listed in subsection 2 of Section 16 of the TIA. There must be a basis for its application so as to refuse bail unless exceptional circumstances are furnished. If Parliament wanted to make it an automatic requirement, it would have stated so in mandatory terms, of course at the risk of contravening Articles 23, Clause 6, Paragraph A, and Article 28, Clause 3, Paragraph A of the Constitution, which guarantee, 1, the right to apply for bail, and 2, the presumption of innocence, respectively. And as lawyers know, no statute can purport to confront a constitutional provision in whatever terms it may wish to do so. Such a purported statement would be null and void. The applicants are accused of soliciting a 20% of an anticipated, soliciting a 20% cut, if I may use that terminology, of an anticipated increase in the budget of UHRC, hoping to exert improper influence on the budget committee, not hoping, promising to exert improper influence on the budget committee and the Ministry of Finance officials to approve the money. UHRC did not concede to the scheme. The budget of UHRC was not increased. The 20% was therefore not paid. In short, the scheme failed. There is no property to recover since none was stolen. Issue number one, therefore, is resolved in the negative. So there is no need to apply exceptional circumstances, because as I've indicated, it was a fruitless hunt.
Court in granting bail was of the view that since the case against them does not involve any personal violence, and that presented sureties are highly paid public officials, with this they are fit to stand sureties for the accused.
I have decided that Section 16 of the TIA may not be applicable. This is not to say that allegations of plotting to steal money from the national budget is not a serious crime. Evidence yet to be verified from PW1, because she's yet to be cross-examined, is that she was told it was standard practice to get a kickback of 5% from MDAs that want their budgets enhanced. In other words, UHRC was not the first or even the last to be recruited into the scheme of stealing money from the population through pilferage of institutional budgets. The court takes a serious view of these allegations and treats this case as grave. Issue number two. Whilst the applicants state that their sureties, who are essentially members of Parliament of Uganda, are substantial, the respondents submitted they are not. Why? Because they have not demonstrated that they have homes or money in their bank to meet the terms of their bond, and that no presumption should be made about this fact. That I should not presume that these honorables have homes or money. In response, Mr. Alaka asked court to believe that members of Parliament do not lack accommodation or homes or means of income. Without much ado, court takes judicial notice of the fact that members of Parliament are the highest paid public officials in Uganda, beating by far any professional groups or technocrats in any MDA. That makes them to be highly paid persons in our economy. They are the only institution which can increase their pay to match an increased cost of living in the country. That puts them in a privileged position financially. It's also a requirement under electoral laws to have a residence in a constituency before standing as an MP. So on that basis of the letters that they attached on their applications showing residence, I find that each of those MPs has a home or residence, be they accused persons or the sureties. The court still has the mandate to entertain an application for bail. The court cannot dismiss an application for bail simply because the trial has started. No. Judicial reasons must be advanced to grant or deny bail. the state submitted that the public good would require that the trial proceeds whilst the accused are on remand. I am aware that currently the country is in a combative mood against corruption. There is awareness among the population about institutions that are suffering under the weight of grand corruption. Going by press and social media reports, the public is now fed up with corruption in public offices. I have given scenarios where bail can be refused in absence of exceptional circumstances. That's where violence is involved, or colossal sums of money, or even trans-border crimes such as terrorism, arms trafficking, human trafficking, and trans-border money laundering are involved. The need to keep such offenders out of society is compelling. But these members of parliament, who have already been on remand now for 55 days, they are alleged to have plotted to execute a scheme which backfired. They did not succeed. They failed. Their trial has already started. They denied the charges. They have credible, traceable, and non-sureties who are public figures. That's the members of parliament. They are not the type who can just disappear under the grass like a green snake. This court treats an allegation of corruption as a serious matter. But before such allegations are proved, I would temporarily consider granting them bail on conditions that reflect the gravity of the case and require the urgent disposal of the matter by setting timelines to fast-track the trial. This would ensure that bail, which is a temporary release from remand, is not abused to frustrate the progress of the trial. And perhaps, ladies and gentlemen, don't try it. Bail would be reviewed. If it is used to frustrate the trial, it will be reviewed because it's my discretion. The case will move systematically to completion within a few weeks. That one, I give you my word. Consequently, I grant bail on the following conditions. Each applicant will execute a cash bail of 50 million Uganda shillings. 2. Each applicant shall deposit his or her passport in court. 3. Each surety will execute a bond of 100 million, not cash. 4. Each applicant shall commit to be available and their counsel to proceed with the trial as required by Rules 5 and 12 Sub-Rule 4 of Legal Notice Number 11 of 2021. If they fail, they are remanded until the 8th, that is Thursday this week, for further hearing. So we commit to the rules. Some like Ocheng's. Mr. Ocheng, you were in the room when we debated these rules.
Although they were granted bail, Paul Akamba will not enjoy his freedom since he has pending charges of corruption and abuse of office in another court. Court will resume on 8th August 2024 for further hearing of the case. Members of Parliament Yusuf Mutembule, Paul Akamba and Sise Namuju are facing charges of corruption for soliciting a 5% bribe from the Uganda Human Rights Commission budget for the financial year 2024-2025.
Addressing that the instance of your client, because they have hired prominent advocates who are known to be paid very highly. So at one time, counsels get, no, you see clients annoyed on the face, and for us we normally see them when they are annoyed, yeah? Because he paid a lot to his counsels, counsel, Lester and others. Yeah? We shall watch the mood. They will be annoyed because of your inaction. So don't be party to the delay of justice. As far as we are concerned, we are committed to ensuring that justice is not only done, but is seen to be done. We shall always do justice without fear or favor. And we shall always ensure that justice is done to all, because that's the vision of the bishop. So bring your client to take it the way it is. State, speak interest in inquiring about the state of the client, but let him not overfall sick because I have extended the criminal summons. You shouldn't be scared by the state speaking interest. And pick interest if investigation is indeed complete. A case like this crowd, we don't need this crowd for a very long time. You can even fix, when it is fixed, High Court is not busy, they will attend it in 2, 3, 4 months, the case will be concluded. Okay? If you intend to commit, start working on the draft. When it takes plea, maybe on the next adjournment, you can commit. If you want to proceed from here, please, the day it takes plea, we shall fix the case for hearing. Now let's agree on the date when we shall come back.
Your Worship,
So if you have a charge sheet, you must come and take it. What is the state of investigation?
Investigations are complete.
Investigation are complete. So you see, you are the only one who is holding us.
I take to bring the next date, Your Honor.
Yeah.
I undertake to ensure he appears in court on the next date, however short it might be, regardless of the other part of being the joint. So that at least it takes place, regardless.
Now I'm going to exercise grace. Okay?
Most of them,
And extend your criminal summons. But on next adjournment, yeah, on the next adjournment, should you feel in whichever state it is, yeah, in whichever state it is, please know that the reception you will get will be different. And if there is any independent report that suggests that the man is actually sick of only this case, you need to stand in the church alone and repent for causing the sickness. Because if you had appeared here and taken you with others, it would be and would have been just a prayer.
Meanwhile, the hearing of the corruption case against the former Executive Director Mulago National Referral Hospital, Dr. Byarugaba Baterana and co-accused flopped again, following the absence of Ewan Batanda Perez, also accused in the case. Although criminal summons were issued against Batanda Perez, he has never appeared in court. Court has now set 16th September 2024 to resume with the case and criminal summons extended against Batanda. Court prosecution informed court that inquiries into the case are complete. Dr. Byarugaba Baterana, together with the other co-accused, are facing charges of abuse of office and causing financial loss to government of over 6.3 billion. Prosecution alleges that the 8 committed these offences between financial years 2015-2016, 2016-2017, and 2019-2020. All the charges against them carry a minimum sentence of 21 years.